Hello everyone, welcome to Law Minds. So today's topic is Memorandum of Association. In this video, we will learn about the different clauses of the Memorandum of Association and their significance, the legal requirements for its alteration, and landmark cases that have helped to shape its interpretation in India. Understanding the Memorandum of Association is crucial for any company that wants to establish a strong legal foundation and operate successfully in India. So, what is a Memorandum of Association? The Memorandum of Association, or we can say MOA, is a legal document that serves as a charter for a company's formation. It is a crucial document as it defines the company's legal identity and purpose. According to the Companies Act 2013 in India, a Memorandum of Association is one of the documents that must be filed with the Registrar of Companies during the incorporation process. It sets out the fundamental and essential elements of a company, including its name, registered office address, objectives, authorized share capital, and liability of members. The MOA outlines the company's scope of activities and serves as a guide to the company's internal operations. The Memorandum of Association must comply with the requirements of the Companies Act and include the mandatory clauses specified by the Act. Therefore, it is essential for entrepreneurs and business owners to understand the significance of MOA and create it with utmost care and attention to detail. The main purpose of the Memorandum of Association is to define the legal identity and scope of activities of a company. It serves as a charter for the company's formation and sets out the fundamental and essential elements of the company. The Memorandum of Association outlines the company's name, registered office, address, objectives, authorized share capital, and liability of members. It also specifies the objects for which the company is formed and operates. By defining these crucial elements, the MOA provides clarity and transparency to the company's stakeholders, such as investors, shareholders, creditors, and regulators. It serves as a guide to the company's internal operations and helps in ensuring that the company is managed in accordance with the legal framework. So, what are the clauses in Memorandum of Association? According to the Companies Act 2013 in India, a Memorandum of Association contains 6 mandatory clauses that must be included during the incorporation of a company. These clauses are name clause, registered office clause, objective clause, liability clause, capital clause, association clause. So, first of all, name clause. According to the Companies Act 2013, the name clause is a mandatory clause that must be included in the Memorandum of Association of a company. It specifies the name of the company and should end with private limited or limited for a company limited by shares or unlimited for a company not limited by shares. The name of the company should be unique and the Registrar of Companies must approve it before the company's incorporation. The name clause should also comply with the rules and regulations laid down by the Ministry of Corporate Affairs. The name of the company should not be identical or similar to any existing company, and it should not be offensive or violate any copyright or trademark laws. The name clause is a crucial part of the Memorandum of Association as it defines the legal identity of the company and helps in identifying and differentiating it from other companies. The second one is registered office. The registered office clause is a mandatory clause that must be included in the MOA of a company. It sets out the registered office address of the company, which is the official address of the company where all legal notices, communications, and documents will be sent. The registered office must be situated in the same state where the company is incorporated. The registered office clause should include the full address, including the city, district, state, and PIN code. It is important to note that any change in the registered office address must be communicated to the Registrar of Companies within 30 days of the change. The registered office clause is a crucial part of the MOA as it establishes the official address of the company and helps in determining the jurisdiction of the company for legal purposes. Third one is the objective clause. The objective clause specifies the objects and purposes for which the company is formed and operated. The objective clause should clearly state the main objects, which are the primary objectives of the company, and other objects which are incidental or ancillary to the main objects. The object should be specific, definite, and not vague or ambiguous. The MOA should also include the necessary incidental or ancillary objects that are required for achieving the main objects. Any changes to the objects of the company must be approved by the shareholders and communicated to the Registrar of Companies. The objective clause is a crucial part of the MOA as it defines the scope of activities of the company and helps in determining the legality and validity of the company's operations. It also helps in protecting the interest of the stakeholders by ensuring that the company operates within the legal framework and doesn't engage any activities that are not specified in the MOA. Fourth one is the liability clause. The liability clause is an essential clause that must be included in the MOA of a company according to the Companies Act 2013. It specifies the liability of the members of the company in case of any debts or losses incurred by the company. In a company limited by shares, the liability of the members is limited to the unpaid amount of the shares held by them. On the other hand, in a company limited by guarantee, the liability of the members is limited to the amount they agree to contribute to the assets of the company in case of its winding up. The Memorandum of Association should clearly state the nature of the company's liability, whether it is limited or unlimited. It's important to note that any misrepresentation or false statement regarding the liability clause can result in severe legal consequences. The liability clause is a crucial part of the MOA as it defines the extent of the liability of the members and helps in protecting their personal assets in case of any debts or losses incurred by the company. Fifth one is the capital clause. The capital clause is an important clause that must be included according to the Companies Act 2013. It specifies the authorized capital of the company, which is the maximum amount of capital that the company can issue to its shareholders. This clause should clearly state the amount of authorized capital, the number of shares, and the nominal or face value of each share. The MOA should also specify the types of shares such as equity shares, preference shares, or debentures that the company is authorized to issue. Any changes to the authorized capital of the company must be approved by the shareholders and communicated to the Registrar of Companies. The capital clause is crucial as it defines the maximum amount of capital that the company can raise and helps in determining the financial capacity of the company. It also helps in protecting the interest of the shareholders by ensuring that the company doesn't issue more shares than the authorized capital. Association clause. The association clause is a fundamental clause that must be included in the MOA. It specifies the name of the company, the state in which the registered office is situated, and the objects for which the company is formed. This clause should also include the names, addresses, occupations, and signatures of the subscribers, who are the persons who have agreed to form the company and become its members. The MOA must be signed by at least 7 subscribers in the case of a public company, 2 subscribers in case of a private company with a share capital, and 1 subscriber in the case of a private company without a share capital. Next is the form of memorandum. The Memorandum of Association of a company should be divided into paragraphs numbered consequently and printed. The Memorandum of a company should be formulated in accordance with the respective forms as mentioned in tables A, B, C, D, and E under Schedule 1 of the Companies Act 2013. Table A is applicable to companies that are limited by shares. Table B is applicable to companies that are limited by guarantee and do not have authorized share capital. Table C is applicable to companies limited by guarantee and has authorized share capital. Table D is applicable to unlimited companies that do not have authorized share capital. Table E is applicable to unlimited companies that have authorized share capital. It is to be noted that at least 7 persons in the case of a public company and at least 2 in the case of a private company must subscribe to the memorandum. Subscribers are the first shareholders of the company. They are the people who agreed to come together and form the company. The name of each subscriber along with their particulars are mentioned in the memorandum. So different kinds of companies require different number of subscribers for incorporation. Private company, in case of a private company, the minimum number of subscribers required are 2. Public company, 7 or more subscribers are required. In case of a one person company, only one person is required. So who all can subscribe? Rule 13 of the Companies Incorporation Rules 2014 describes the provisions of subscribing to the memorandum. There are specific kinds of persons, both natural or artificial, who can subscribe to the memorandum. These are minor. A minor can only be a subscriber through his guardian. Company incorporated under the Companies Act. The company can be a subscriber to the memorandum. The director, officer, or employee of the company or any other person authorized by the Board of Resolution. Third one is company incorporated outside India. Foreign company is defined in Section 2, Subclause 42 of the Act. It states that a foreign company is a company incorporated outside India. A company registered outside India can also subscribe to the memorandum by fulfilling the additional formalities. Next is society registered under the Societies Registration Act 1860. Fifth one is limited liability partnership. A partner of limited liability partnership can sign the memorandum with the agreement of all the other partners. Next one is the alteration of Memorandum of Association of a company. The MOA is a vital document that defines the constitution, the scope of activities, and the powers of a company. However, the Memorandum of Association may require alterations in certain situations, such as changing the name of the company, increasing the authorized capital, or altering the objects clause to reflect the changing needs of the companies. The Companies Act 2013 provides a detailed procedure for the alteration of the MOA, which involves obtaining the approval of the shareholders and complying with the provisions of the Act. The procedure for the alteration of the MOA includes the following steps. Convening a board meeting. A board meeting should be convened to approve the proposed alterations to the MOA. Convening a general meeting. A general meeting should be convened to obtain the approval of the shareholders for the proposed alterations to the MOA. Filing of a special resolution. A special resolution should be filed with the Registrar of Companies, that is ROC, within 30 days of the passing of the resolution. Approval of ROC. The ROC or the registrar of companies will scrutinize the special resolution and, if satisfied, will approve the alteration of the Memorandum of Association. Issuance of Certificate of Incorporation. The ROC will issue a fresh Certificate of Incorporation reflecting the alterations made to the MOA. It is important to note that any alteration to the Memorandum of Association must be made in compliance with the provisions of the Companies Act 2013 in India and any other applicable laws. Also, the alteration should not be inconsistent with the existing provisions of the MOA and should not adversely affect the rights of the shareholders or the public. So now the question is, what can be altered in an MOA? According to the Companies Act 2013 in India, the MOA can be altered by making changes to its various clauses, such as the name clause. The name of the company can be changed by altering the name clause. Object clause. The object clause defines the objectives and powers of the company. This can be altered to reflect the changing needs of the company or to include new objectives. The liability clause. The liability clause specifies the liability of the members or shareholders of the company. It can be altered to change the liability of the members from limited to unlimited or vice versa. Capital clause. The capital clause defines the authorized share capital of the company. It can be altered to increase or decrease the authorized share capital. Registered office clause. This can be altered to change the registered office from one location to another. Next topic is Memorandum of Association of a one-person company. So the Memorandum of Association is a critical document for a one-person company. In India, And one person company is a type of business entity that is owned and managed by a single person, and the Memorandum of Association serves as a guide for its operations. The MOA of a one person company must comply with the provisions of the Companies Act 2013 and must contain clauses that outline the company's objectives, powers, and limitations. A one person company is called so because it can be formed by one person. The minimum capital required to form a one person company is 1 lakh rupees. It's a new concept which has been introduced to promote entrepreneurship. All the laws which are applicable on private companies will be applicable on one person company. Section 2, Clause 62 of the Companies Act 2013 defines one person company. In case of one person company, in addition to all the other clauses, the Memorandum of Association contains a clause called the nomination clause. This clause mentions the name of an individual who will become the member in case the subscriber dies or becomes incapacitated. The nominee must be an Indian citizen and resident of India, that is, he must have been living in India for at least 182 days in the preceding year. A minor cannot be a nominee. The individual whose name is mentioned should give his consent in written form, and it is required to be filled with the registrar of companies at the time of incorporation. If the nominee wants to withdraw, he shall give it in writing, and the owner of the company will have to nominate a new person within 15 days. Significance of Memorandum of Association. So, there are many important uses of Memorandum of Association. Some of these are legal standing. The MOA provides the company with a legal standing by clearly defining its objectives and scope of operations. It acts as a contract between the company and its members. Investor confidence. Potential investors and stakeholders often scrutinize the MOA to understand the company's purpose and direction. A well defined MOA can instill confidence in investors. Regulatory compliance. The MOA ensures that the company operates within the legal framework. It helps in avoiding activities that are beyond the company's legal capacity. Protection of shareholders. The MOA protects the interest of shareholders by clearly stating the company's objectives and preventing the management from deviating from the agreed upon purpose. Next, we can learn some of the case laws. The first case law here is Ashbury Railway Carriage and Iron Company Limited versus Rich 1875. This case established the principle that the objects clause of the Memorandum of Association is a fundamental document that determines the capacity and powers of a company. The objects of the company must be clearly stated in the MOA, and any activity that falls outside the scope of the objects clause is considered ultra vires or beyond the legal power of the company. Next case law is Raila Corporation Private Limited versus Director of Income Tax 2016. In this case, the Supreme Court of India held that the MOA must be interpreted in a manner that is consistent with the provisions of the Companies Act 2013. The MOA cannot be used to circumvent the statutory requirements or to engage in activities that are prohibited by law. Next is Sterling Computers Limited versus Messrs. M&N Publications Limited, 1993. This case established the MOA of a company is a public document that can be inspected by any person upon payment of the prescribed fee. Any alteration or amendment to the Memorandum of Association must be filed with the Registrar of Companies or ROC and must comply with the provisions of the Companies Act 2013. Messer Holdings Limited versus Shyam Madan Mohan Ruia, 2019. In this case, the Supreme Court of India held that the MOA of a company cannot be used to evade statutory obligations. The company cannot cite the Memorandum of Association to avoid compliance with statutory requirements or to engage in activities that are prohibited by law. These landmark cases have played an important role in shaping the interpretation and understanding of the provisions related to MOA in India. Thus, we came to the end of the session with the conclusion of This topic, that is, the Memorandum of Association, is an essential document for any company in India. It outlines the company's objectives, powers, limitations, and serves as a guide for its operations. The MOA is a public document that can be inspected by any person, and any alteration or amendment to the MOA must comply with the provisions of the Companies Act 2013. The MOA cannot be used to circumvent statutory requirements or to engage in activities that are prohibited by law. Landmark cases such as Ashbury Railway Carriage case or the Rayala Corporation Private Limited case have helped to clarify the legal interpretation of the Memorandum of Association in India. It is crucial for companies to understand the clauses of the MOA and their significance in order to avoid any legal disputes or challenges. By adhering to the rules and regulations and guidelines outlined in the MOA, companies can establish a strong foundation for their business and ensure compliance with the law. Thus, we come to the end of the session. Thank you all. Please like, share, and subscribe the channel Law Minds. Thank you.